Uh, Welcome all of you. Today we shall be discussing about a topic of our syllabus that is called the intellectual property rights. Uh, Before going for further discussion about today's topic, let us sum up what is discussed till now. Till now we have discussed the scholarly communication process, how academic publication process works, the peer review and academic misconduct activities that generally happens, and the COPE publication ethics. The summary and various presentations about all these topics have been shared with you already. I hope you all have gone through these documents that I have shared. Today's tutorial's discussion point will be we shall be discussing what is intellectual property rights, what are the various categories of IPR and IPR in the Indian context, and the drawbacks of intellectual property rights. So basically, let us know about what is intellectual property rights. Basically, intellectual property refers to the creation of mind, that is, any kind of invention that has been done by the scientist are covered under the intellectual property. The literary and artistic works, that is, the poem written by a poet, the novel written by an author, or the academic research articles published by scientists are covered here. Various designs, various symbols, names, and images that are used in commercial purposes, like the trademarks. These all are covered under the intellectual property regime. And this intellectual property are covered under by some law. And these laws are called the intellectual property rights. That means the creators of those intellectual property are given the right to earn recognition for their creativity, based on which they can earn some financial benefit. This is the main motive of any kind of intellectual property law. And this kind of IPR laws try to create an environment in which creative and innovation can flourish. As because financial benefit is there, so that a person can earn his livelihood by virtue of this intellectual property rights. So basically, intellectual property protects four kind of ideas. The first one is trade secret, the secret information regarding any industrial creation, like the Coke formula we can say about, or any kind of new invention. These are the trade secrets. And trademarks, the symbols through which a brand is created. For example, the Apple logo of cell phones. And copyrights protects the works of an author, like book, movies, drawings, etc. And patents protects the functional ornamental features, like swipe feature in an iPhone design. That is a patent for the Apple company. So these are the various uh, four prime categories of intellectual property. And these four prime categories of IPR is actually divided into two basic categories. One is IPR have two branches. First one is the industrial property rights, under which the design, patent, trademark, trade secret, etc. comes. And the another branch is copyright, under which the music, arts, the literary works comes. So industrial property basically relates to the industrial creations, and copyright relates to the creativity features, like a cinema, a novel, etc. So before going, IPR came into existence by these two conventions that have happened. Basically, these are the result of the industrial revolution that was going on in Europe. First one is the Paris Convention that has happened in 1883, and this Paris Convention was directly related to the industrial property creations. And later in 1886, this Berne Convention came, and this Berne Convention was for protection of literary and artistic works. So these are the prime historical events based on which modern intellectual property laws are created in different countries. So basically, why IPR is necessary? Earlier, we have told that IPR is giving the creators the right for their innovation, and based on which they can get some economic and social rights. This is the prime necessary of IPR. So, as a researcher or as a student, as a creators, we are more concerned about the copyright policies because industrial right is mostly related to the industrial creations only. But as a student researcher, we are will be mostly dealing with the laws of copyright. And copyright gives some economic rights to the copyright holder. What are these? It allows the right owner to earn financial benefit from use of their words. That means an author can write a novel and he can earn money by selling that novel, and nobody can make a copy of the novel and sell it. This will be called as the piracy. The copyright holder can reproduce the work in various forms, such as printed publications to sound recording. That means an author can write a novel and later he can release the audiobook for the novel also, for which he will be earning the money. The copyright owner have the sole right to distribute the copies of their work. Public performance of the work, broadcasting or other communication of the work for the public. And the other forms like translation of the work will also be held with the copyright owner. So these are the economic rights that are given to the copyright owner. And basically, you all might have been hearing about all these things like public performance. That means we can go watch a cricket match and live that cricket match in your Facebook or social media profile, because that cricket match broadcast right has been already sold to some certain company by the actual copyright owner. Similarly, distribution of copies of works. A new series have come up in Netflix. You can't just download and distribute it. This will be the sole violation of copyright works, because what you will be doing will be piracy. So these are some examples that I have shared with you, and these are the basic economic rights that are given to the copyright owners. But there are some special cases for which their copyright have some exclusions. For example, when you all shall be writing some research papers, or you all shall be doing your dissertation works, you will be using some other copyrighted works like previous research papers or some definitions from books. For those kind of works, you have to quote from a protected works. That means you can use the quotation name. If you are using a definition, you can quote that definition with the author name. That means the citation process. So if you cite something like that, it will not be a violation of copyright. Also, use of works by illustration or for teaching purposes. That means you can use the copyrighted works while you shall be teaching. Suppose you are teaching someone how to make a documentary. For that purpose, you can use you can use another movie which you will be showing to the students for creation of the documentation, for teaching how to make documentary movies. Like for news reporting purposes also, these works are excluded from copyright. And these all uses terms are called as fair use under copyright policy. So these three are the areas where copyright laws are excluded, and these are called the fair use policy under copyright. So things under in India are protected by the Indian copyright law that was came up in 1957 and amended in 2012. The Indian copyright law adheres to the Berne Convention, Paris Convention, World Intellectual Property Organization, Rome Convention, etc. And in India, copyright lasts for the lifetime of the authors and 60 years after the author dies for literary, dramatic, musical, and artistic works. That means if an author writes a novel, he will hold the copyright for the novel for his entire lifetime and after 60 years of his death. That means if an author dies in 2020, so his copyright for the works will be over after 2080 only. That means it is protected after 60 years of death also for the copyright holder. And now currently there are various drawbacks that hinders free flow of information in the academic community. So copyrighted works have tough reuse policies. That means we already got under the fair use policy that whenever you use it, you have to quote the works and you can only use it for teaching purpose or news reporting purposes. That means they have very tough reuse policies that hinders the free flow of information in the academic community. They have tough reproduction policies. That means you can reproduce a copyrighted work, but those are very much necessary for in case of preservation purposes. And all these two things hinder the free flow of information in the academic community, that hinders creation of new information. And these copyright laws are now exploited by the academic publishers, the journals, book publishers, based on which they make money, but the actual creators doesn't get the money. For example, whenever an author publishes an article in a journal, after publication, the publisher will sell those articles. Like if you have to access an article, online article, that means you have to pay this much sum, but this sum will be solely obtained by the publisher of the content, and this money, the actual author for the journal or research article, they will not get the money, the publisher will only get the money. So like this price varies. Buy this article, if you go to online and wish to read some articles, you have to buy this article. That means 34 pounds, this much amount of money you have to pay for reading just one article. Like this, the publishers are, academic publishers are exploiting the copyright laws, and which is hindering the free flow of information in the academic community. For example, whenever you will be publishing an article, you have to sign an agreement called a copyright transfer agreement to the publisher. If as an author you write a research article, before publication you have to sign this copyright transfer agreement, and in this agreement you will be giving some rights to the publisher, where the publisher can make money based on your own research area. That means as a researcher you will be using your mind, you will be using your time, but ultimately the publisher will make money based on your research. So, and the publisher is doing it legally because publisher have the right under the copyright law. So in our next discussion we shall be discussing about how these copyright laws have, more detailed about how these copyright laws have hindered the free flow of information in the academic community, and what are the new measures of publication model are coming out in our academic community. So till now, please watch this video, and I shall be posting the next video tutorial in next 2 days. Thank you.